Hello, welcome to my channel. I am Thomasin PA2066. Today is 25th of February 2023. I like to do a series on frequently asked questions, and this is episode number 3 on ownership dispute. And before I do that, I like to disclaim that this is not legal advice, as I am not a legal qualified lawyer. However, this is for educational purpose and sharing for the reason that I see questions like this frequently asked among the public. Let me continue. Hi, this is video number 142. Frequently asked question in real estate, episode number 3, ownership dispute. I'm Thomasin PA2066. Today is 25th of February 2023. Let me begin this topic on issue of ownership dispute, especially when 2 or 3 persons join name to buy property, and during the time where some of the co-owners or co-proprietors actually pay more than the others, and they claim that this paying more, being contributing more to the property, the right of taking more money. So this part is like if 2 persons join name to buy a property, by right is 50%, 50% each, but end up that the person says that I have been paying full, so I should have the full proceed to the sale of the property. So the common question in the case is a lot of time during courtship or among siblings, when this occurs, as in, boyfriend and girlfriend wanting to have a love nest, and then they are the two in a really hormonal emotion, and then therefore they rush in and bought a property. But most of the time, maybe the man, the boyfriend, actually contributed, and then the lady eventually on the sale of the property wants to have more portion. Also, these are dispute over some hearsay and commonly heard siblings as well. When the parents give away inheritance of property, let's say to 4 children and 25% each, and at the times that the elders would say that because of the work that has been done, repair and doing all kinds of uplifting of the house, that he has the right to own more. So this is a common question that is asked. So I like to also say that this law affects you, as in the general public, who we deal with land ownership of property, so we need to understand. But on the other hand, I also want to disclaim that I am not a legally trained person. I am not giving a legal advice here. It's more for education and knowledge. So this disclaimer means I want to highlight that you consult your lawyer, as whatever material presented in this presentation does not constitute a legal advice. Okay, name not in title but paid monthly. So who can own the property? Right to claim ownership. Do you have a right when you actually paid for a lot of monthly installment, but your name is not in the property? Give you a few examples. So background, I am a Malaysian but working in and living in Singapore for many years. This is a very good standard example. A lot of time happens in Johor. So I am in joint name with my mother, who is already senior age and being cared by my sister. So let's say a sister caring for the mother, and the other elder sister working in Singapore sending back money. So my sister is not working because having to take care of the ill or senior age mother, and therefore not able to work. And I make better income in Singapore. Of course, when the younger one take care of the mother, the elder one in Singapore make more money and send back the money to pay off the house installment, the mortgage. So I paid for monthly installment fully myself, and then my sister does not pay anything. So this is a scenario, quite common scenario. Another scenario is I am a Malaysian working a decent salary as well, maybe in overseas. My boyfriend and I have been cohabitating for 3 years. So they are not married but cohabitating. This happens a lot in the Western countries. Now we found a lovely house in our neighborhood which we want to buy and join them in Malaysia. I say come back into settling down in Malaysia. So I paid for the down payment, which is let's say 80,000 and then my entire saving with my boyfriend who is probably not able to come out with the down payment. So I take up mainly 50% of the monthly installment. And over years, boyfriend and girlfriend cohabitating, but then unfortunately, the thing did not end in a good union. So they were forced to maybe go in a diverse way, not divorce because they are not married. So the thing is that the house actually is in joint name because the boyfriend and the girlfriend join name to buy the house. So what would be the case in this scenario? So what will happen to the property ownership when this thing happens? The mother passes away or the boyfriend leaves the lady. So in this case, the 50% owned by the mother and the 50% owned by the boyfriend, what would happen? So the issue at hand and the argument is that the land law says that whatever is in the title, title is the mother of everything. So the indivisibility of the title. So if you hold the title and your name is in the title, then that means you own the property. No dispute, no challenge. That is the final. So the issue here is the mother owns 50% and the boyfriend also owns 50% in both cases. So they are actually proprietary owner and they have a right to the property. So here the answer for inheritance, let's say the mother passed away and gave a will, written a will to pass her 50% to the younger sister who took care of her. So this means that the younger sister would have the 50% ownership, which is passed down by the mother to her inheritance of her sister. So the sister would have 50% of the property, despite the fact that she has not paid anything to the property. It's the elder sister in Singapore that has paid full. So if the scenario like that, if ever it was sold, then 50% of the proceeds of the sale would go to the younger sister. So the core proprietorship means 50% each of the owner. So similar in the case of cohabitating, if indivisibility of the title means that the boyfriend's name, joint name, is 50% ownership of the property, and despite that you have paid 80,000 as a down payment and he had paid nothing, only sharing out 50% of the monthly installment. Despite that, is the proceed 50% of the house would still go to the boyfriend. So like to maybe just say something about this. How about married people? Let's say you are, instead of cohabitating, you are married. Is there a difference? So yes, there is a scenario. It's a marriage law, and in Malaysia, if it's a married couple who claim over the ownership of the property in court, let's say over the dispute over divorce settlement, usually the judges, the judge of the court would look into scenario similar as to protect both parties with the best outcome. Example, if it's a joint name property, the scenario that the wife who actually has worked very hard with the family but did not pay anything, then by right the wife would have a 50% share, even though the property has no her name in the property. So that means the husband bought the house as they get married, and then over the years she has been married to this man, staying in the house, work herself, helping the husband. But then at the time of divorce, her name is not the name in the joint. It's not a joint name in the property. The court would still award 50% rightful part for her in the property. Similarly, if the women would have paid a lot more than the man in the house, let's say the woman has paid 80%. Including the down payment, the case of cohabitation just now, if it's a case of cohabitating, getting married, and then she has paid more, then she has the right to claim more portions. The court would award to her the more rightful portion for her ownership. Of course, such case also that the court will look into the scenario of both sides. So scenario of both sides, but usually the court would lean more to the weaker party. So in fact, in certain situations, the court may even award full ownership to the wife, although the husband has a 50% share. So such case has been the wife paid more to finance the property lah. So there are a lot of things that may have differently may be treated or subject to different treatment if it is affected by different law. So in the case of marriage, there is marriage law, and definitely the court would weigh the differences between the different interpretation of the law. So the conclusion ownership dispute is that ownership is enshrined in the title of the property, indivisibility of the title. If there is a title and your name is 100% in the ownership, then there is no party that can challenge you apart from situation like case of a land acquisition, the government can through land acquisition act take over the land, but to compensate you 100% compensate you. However, proof of commitment and payment of installment would claim the right of property ownership, especially in a divorce in a court of law, like in the High Court for divorce cases. Thank you. My platforms, including in the platform is e-learning system for the board exam. I have 2 advertising platforms and also a blog which collects my video. And thank you very much for coming to my channel. I'm Thomas Sim, PA2066. This is my mobile number and my website addresses. Thank you again for coming to my channel.